When you start digging into the foundations of Australia, especially the relationship between Indigenous peoples and the state, well, you uncover a story that's far more intricate and ongoing than the simple narratives we often hear.
Yeah, absolutely. It's fundamentally about sovereignty, isn't it?
Hmm.
Who holds it, how it was claimed, and crucially, what it actually means today.
Exactly. And the legal academic articles we've been immersing ourselves in for this deep dive, they really pull apart the layers of this complexity.
They certainly do. They challenge those easy answers and push us to understand the historical and present-day arguments, all that stuff around indigenous sovereignty and rights.
Okay, so let's get straight to it. Our mission today for you tuning in is to kind of extract the essential legal and political arguments. We're looking at Indigenous sovereignty, self-determination, and that ongoing quest for constitutional recognition in Australia.
We'll try to keep the heavy legal jargon, manageable.
Yeah, definitely. But be prepared for some, well, surprising historical context that might just shift how you see things a bit.
So what's really fascinating to examine right away is how the Australian legal system itself has grappled with this whole concept of sovereignty, particularly in relation to Indigenous claims.
You mean like those early high court cases?
Exactly. Covey Commonwealth 1979 and again in 93. They're key examples. In those cases, the sovereignty claims were framed as being adverse to the Crown.
Adverse to the Crown. So, meaning if the court had acknowledged those claims, it would have directly contradicted the legal basis of the Australian government itself, right?
Precisely. It would have been a fundamental challenge to the system. The High Court's position basically was that a nation's foundational acts, establishing sovereignty, well, its own courts can't then just turn around and overturn them.
Right. It's like you can't use the rules of the game to say the game shouldn't have started in the first place.
That's a good way to put it. One of our sources puts it succinctly. The initial acquisition of territory by a sovereign power is seen as an act of state.
Hmm.
Domestic courts just can't challenge that.
Okay. So, claims that essentially said, hang on, Aboriginal nations always held sovereignty, so the Commonwealth's claim is invalid.
Those were sort of non-starters in Australian courts.
Legally, yes. They weren't justiciable, as the lawyers say.
But this is where it gets interesting, isn't it? The articles we're looking at, they explore this other idea, sovereignty claims that aren't adverse to the Crown. What's the core of that argument?
Well, the argument, and it's laid out really well in one of the articles, proposes that Australian common law could actually recognize a pre-existing Indigenous sovereignty, one that continues to exist alongside Crown sovereignty.
Alongside it. So not challenging the Crown's existence, but acknowledging another source of law or authority.
That's the idea. The crucial point is that this kind of recognition wouldn't aim to, like, dismantle the current legal framework. It's about coexistence.
So how would that work?
The thinking is, if Aboriginal peoples can clearly demonstrate the ongoing existence of their own distinct laws and customs, then a form of their original sovereignty could be acknowledged by the common law. Okay, so it depends on demonstrating that continuity.
Exactly. And it draws some parallels, with concepts like domestic dependent nations, which you see in the U.S. context with Native American tribes. Think of the Cherokee Nation cases.
Right. And I remember the Coe cases argued that Aboriginal people didn't fit the description of an organized, distinct political society back then.
Oh.
But maybe that view needs revisiting.
Well, that's what some of the analysis suggests, yeah, that perhaps it's time to look again based on a deeper understanding of Indigenous social structures, their legal systems.
And there's that other distinction, too, isn't there? External versus internal sovereignty.
Yes, that came up in the Yarmir case. External sovereignty is about how a nation deals with other nations, internationally. Internal sovereignty is about the power to govern within its own borders.
Okay.
And the key insight from Yarmir is that internal sovereignty isn't necessarily this monolithic, indivisible thing. It can actually be divided up within a single constitutional framework, shared, if you like.
So recognizing some form of Indigenous sovereignty, maybe including aspects of self-determination, the power to make decisions about their own affairs, wouldn't automatically mean the sky falls in. It wouldn't break the Australian legal system.
That's the core argument. It wouldn't fracture a skeletal principle of our legal system, as one source puts it.
And supporting this is the idea of a nation. What makes a group a nation?
At its heart, it's a distinct group of people with shared characteristics. Right?
Hmm.
The articles argue that Aboriginal peoples clearly fit this definition. They have unique laws, distinct customs, and that profound, undeniable connection to their lands. The Yorta case looked closely at these elements.
Yeah, that makes sense. If you have your own established rules, traditions, deeply tied to specific territory, that sounds like a nation to me.
hmm And even just maintaining some level of organized control over your internal affairs, day-to-day stuff, that could indicate a continuing national identity, even if it's, operating within a broader state structure,
Yeah.
a dependent nation, perhaps.
Okay. Now, to really get a handle on these current legal arguments, we absolutely need to look back at the history, don't we? How British sovereignty was actually asserted and how that view has been, well, critically reevaluated.
We do,
Yeah.
because the common understanding, the sort of storybook version, is that the British just showed up, planted a flag, and declared sovereignty. Bing, bang, boom.
Yeah, instant ownership.
But our sources suggest the reality on the ground and even the legal thinking back then was much more nuanced, complicated.
Oh, so.
Well, one article points out that this idea of immediate, uncontested British sovereignty is maybe more of an enduring myth than actual historical fact.
Really?
Yeah. In reality, the British felt quite insecure about their control over the territory for a long time, maybe the first 50 years or so after arrival.
For 50 years. That's a long time to feel insecure. That really shifts the perspective. It wasn't this instant, universally accepted takeover then.
Not at all. Even someone like Sir William Blackstone, a hugely influential legal commentator back in England, he expressed misgivings, concerns about the legitimacy of colonizing lands that were already inhabited by people.
So even key legal figures weren't entirely comfortable with it.
It seems not. And the legal justification that eventually sort of solidified the British claims that doctrine of terra nullius, the idea the land was empty, belonged to no one.
Yeah, nobody's land.
Right. That didn't get full legal endorsement from the Privy Council until the late 1870s in a case called Cooper v. Stewart.
Late 1870s, that's a full century after the first fleet.
Exactly. So for 100 years, the legal basis was, shall we say, somewhat shaky. Certain.
Oh. Okay. Then, fast forward to the late 20th century, and the High Court, in that landmark Mabo decision, finally overturns the fiction of terra nullius.
A monumental legal correction, yes, a watershed moment. It recognized the prior occupation, the deep connection of indigenous peoples to their lands.
It also created a problem, didn't it? Or revealed one.
Well, yeah. As Justice Nettle pointed out more recently in the Love case, rejecting terra nullius actually created a kind of gap in the common law.
A gap.
If the acquisition of territory wasn't based on the idea of an empty land, then how was it lawfully acquired by the British? What was the legal basis then?
Right. That's the fundamental question, isn't it? If it wasn't empty, how did you bet it?
Precisely. This gap, as Nettle called it, suggests an incomplete story, an unresolved issue right at the heart of the relationship between indigenous peoples and the Australian state.
So what's the solution to filling that gap?
Our sources argue pretty strongly that this outstanding matter needs resolution through negotiation, potentially leading to treaties or maybe other forms of agreement.
And this isn't just a domestic Australian issue, is it? There's an international angle, too.
Definitely. From an international law perspective, legal scholar Dilia Opekokyu makes the point that the old doctrine of discovery, the idea that European powers gained rights over indigenous lands just by discovering them.
Yeah, finders keepers.
Right. That's just not considered good law anymore internationally. It's been widely discredited.
Okay. So the foundational narrative, the story we've inherited about how Australia became Australia, it has some pretty significant legal holes, both domestically and internationally.
That seems to be the conclusion, yes.
Which brings us logically to the concept of self-determination. Now, that's a term we hear a lot. But what does it practically mean for indigenous peoples within the Australian context, according to our sources?
Yeah, it's crucial to unpack that.
Yeah.
The articles make it clear that indigenous self-determination doesn't automatically mean, secession or redrawing national borders or creating a separate indigenous state.
Okay, that's important.
While international law does recognize the possibility of independence in certain decolonization situations, that's not necessarily the primary focus here, especially within existing states like Australia.
So where does the right come from then?
The UN Charter itself emphasizes the principle of equal rights and self-determination of peoples. And this principle isn't just for former colonies overseas. It's considered applicable within existing nation-states, too.
So Australia actually has international responsibilities to ensure indigenous peoples can exercise their right to self-determination within Australia.
That's the argument. It's a complex area, though. You look at the CAN's U.S. states, that's Canada, Australia, New Zealand, and the U.S.
Right. Similar colonial histories in some ways.
Exactly. And they have this unique sometimes quite contradictory history with Indigenous rights internationally. For instance, they were involved in developing the UN Declaration on the Rights of Indigenous Peoples, UNDRAP.
But didn't they vote against it initially?
They did. They were among the very few countries that voted against its adoption, which highlights a real tension, doesn't it, between perceived national interests and these evolving international legal and ethical norms.
Yeah, definitely. But the right itself, self-determination, it's pretty well established.
Oh, yes. It's firmly rooted in core UN documents. Article 55 of the Charter, UN General Assembly Resolution 1514, which is widely seen as a foundational principle of international law now. And academics like Linda Tuwai-Smith argue very powerfully that Indigenous peoples in Australia unambiguously qualify as peoples who possess this right.
Okay, so they are peoples with a right to self-determination. If that doesn't necessarily mean creating a new country, what could it look like in practical terms inside Australia?
Well, while external self-determination, full independence, might not be seen as immediately practical or even desired by all Indigenous groups, the focus shifts to internal self-determination.
Internal, meaning?
Meaning Indigenous peoples having a significant degree of control over their own affairs within the existing borders of the Australian state.
Okay, like managing their own communities, resources, culture.
Exactly. The International Court of Justice has talked about different ways this can happen: independence, free association, or integration. But the key is always that it must be based on the free and genuine will of the people concerned.
Free and genuine will.
Okay.
And free association is one model that comes up in the sources, right? What would that sort of arrangement look like?
It suggests a relationship built on mutual agreement and respect within the existing Australian federal system. It could involve a division of powers, sometimes called vertically divided sovereignty.
Vertically divided. So like federal and state governments, but also an Indigenous level of government with defined powers?
Potentially, yes, where Indigenous peoples have real autonomy and decision-making authority over matters that directly affect their communities, their lands, their culture.
This sounds like it leads us straight into the need for things like treaties or maybe constitutional change. These seem like the most concrete ways to give legal and political force to these ideas.
Absolutely. They're the mechanisms, really. And interestingly, even the agreements negotiated under the Native Title Act. Well, some argue they don't fully realize self-government yet, but they definitely share important characteristics with treaty making. Well, take the Hope Vale Deed of Agreement, for instance. It recognizes specific rights for the native title holders regarding their land and also their internal governance, things like resolving disputes, determining who belong to the group.
So these existing agreements already provide little pockets, maybe, of how Indigenous self-governance can operate within the current system.
You could see them that way, yes.
Yeah.
Concrete examples. And that concept of two peoples, the British and their successors on one hand, and Indigenous peoples on the other, forming distinct political communities. That came up in the Love case around citizenship.
Right.
That really underscores the potential for negotiating a new relationship, a nation-to-nation or people-to-people relationship between these distinct groups.
And presumably, Indigenous peoples could also look beyond Australia's borders for support.
Our sources point that out too, yeah. Pursuing international avenues, political advocacy on the global stage to advance claims for decolonization or self-determination.
Though some propose more radical domestic change, like Michael Mansell's idea.
Yes, he's argued for establishing a new Indigenous state within the Australian Federation. That's certainly a significant proposal on the table.
But perhaps those free association agreements within the existing constitution, but involving that shared sovereignty, that seems like a more maybe immediately achievable goal for many.
It could provide a way, yeah, a mechanism to actually write down, to codify a preferred model of self-determination into Australian law. A model chosen and agreed upon by Indigenous peoples themselves, perhaps through a treaty process.
And there's even an argument that self-determination is just cogents. What does that mean?
Cogents means it's considered a peremptory norm of international law, a fundamental principle that's so important, no state can opt out of it or violate it. It overrides other laws or treaties.
Wow, okay, so it's a really powerful claim in international law.
It is. And then, when we think about constitutional amendments within Australia, our sources often point to Canada. Section 35 of the Canadian Constitution.
What did it do?
It explicitly recognizes and affirms existing Aboriginal and treaty rights. It's provided a constitutional framework for ongoing negotiations and the recognition of Indigenous rights there. It's seen as a significant reference point.
And in Australia, we have Section 51, the race power. That's been used for the Native Title Act, right?
Yes, that's the constitutional head of power used for the MTA. But it also allows for quite flexible agreement-making processes, like Indigenous land use agreements, ILUAs. The big Noongar settlement ILUA in WA is an example. These can incorporate elements of local self-determination agreed between the parties.
Now, speaking of the Constitution, we have to talk about the 1967 referendum. It's often held up as this major turning point for equality. But our sources suggest it's maybe not that simple, that it didn't fully achieve genuine recognition or equality.
That's a really crucial nuance, yeah. The original Australian Constitution, written back in the 1890s, contained explicitly discriminatory provisions against the Aboriginal race.
Like not counting people in the census.
Exactly. Section 127 excluded them from the count. The 1967 referendum achieved two key things. It repealed that Section 127, and it amended Section 5126, the race power, to remove the discriminatory wording and allow the Commonwealth to make laws for Aboriginal people.
Which was a huge symbolic victory, obviously, a massive yes vote.
Undoubtedly, a clear expression of public will for change, but it didn't deliver full formal equality. And the ongoing pursuit of Indigenous recognition is often described, quite rightly, I think, as unfinished business.
Unfinished business. Why? What was left undone?
Well, a vital point raised in the articles is about that amended Section 5126, the race power. Even though the Yes campaign implied, and many believed, that the Commonwealth would only use this power to benefit Indigenous people.
That's not how it's been interpreted legally?
No. The High Court has basically said that making laws for Aboriginal people doesn't necessarily mean for the benefit of them. The power could, theoretically, still be used to make laws that are detrimental.
So the very power that was supposed to help could potentially harm.
That's
quite sobering.
It is, and that's why the expert panel on recognizing Aboriginal and Torres Strait Islander peoples, back in 2012, made some strong recommendations.
What did they suggest?
They recommended getting rid of Section 51 altogether, and also Section 25, which contemplates states disqualifying people from voting based on race.
Get rid of those and put something else in.
Yes, insert a new non-discrimination clause, Section 116A. Though, it has to be said, the very definition and application of race in legal terms is still a really complex and debated area.
So in the meantime, there's the idea of symbolic recognition, just acknowledging Indigenous peoples as the first inhabitants in the Constitution.
Yeah, that's often discussed. Our sources suggest it could be a really valuable first step, an important foundation, perhaps, a symbolic statement of historical truth and recognition that might pave the way for more substantive changes down the track.
It feels like this whole discussion, law, sovereignty, recognition, it just highlights how vital it is to have Indigenous voices within the legal system itself. And our sources also look at the barriers Indigenous people have faced getting into law, don't they?
They do, and it's a critical dimension. Historically, I mean, Indigenous people face severe limitations in accessing any kind of decent education until well into the mid-20th century, let alone law school.
And the pioneers faced real prejudice.
Absolutely. The experience is shared by people like Mulanjawaka, Lloyd McDermott, one of the earliest Indigenous lawyers, being told he wasn't a real Aborigine because he was a lawyer. That just vividly illustrates the kind of disbelief and prejudice they were up against.
That's incredibly stark, isn't it? A direct challenge to your identity just for pursuing a profession.
And while there's been significant growth since then, thankfully, in the number of Indigenous lawyers and legal scholars, research suggests they can still experience this really complex double bind.
The double bind.
Yeah, feeling pressure to fit into a sort of race-neutral professional mold, while at the same time facing expectations, often unspoken, to take on extra race-specific responsibilities, advocacy for their communities, that sort of thing. There's an analogy used about Indian abductee stories, this feeling of being caught between two worlds, potentially alienated from both.
And the law schools themselves have been criticized.
Strongly. Nicole Watson's work, Indigenous People in Legal Education, staring into a mirror without reflection, is powerful. She basically argues that Australian law schools often function as racial hierarchies, failing to properly acknowledge or value Indigenous knowledge systems and perspectives.
And academics face challenges too.
Oh, yes. The sources describe common experiences for Indigenous legal academics. Feelings of isolation, being overloaded with unreasonable expectations for service and community engagement, and encountering subtle but persistent forms of racism within their own institutions.
Professor Heather Douglas's research talked about the whiteness of the law school, didn't it, as a source of alienation for students?
Yes, that pervasive sense that the whole environment, The curriculum, the teaching methods, the culture is just fundamentally based on non-Indigenous norms and perspectives, making it hard for Indigenous students to feel they truly belong or that their own backgrounds are valued.
So support programs are important, but maybe not the whole answer.
Exactly. Our sources suggest that while specific support programs for Indigenous students are crucial and can be very effective, they often focus more on helping students fit in or adapt to the existing system.
Rather than changing the system itself.
Precisely.
Yeah.
Rather than driving fundamental institutional change to make the law school genuinely inclusive and culturally responsive.
And it's sad to read that the reality of ongoing racism might even lead some Indigenous students to hide their identity.
It's deeply concerning.
Yeah.
The constant need to anticipate or navigate racism can be exhausting. Choosing to keep your identity private might feel like a necessary protective measure, but it comes at a significant personal cost, limiting connection and authenticity.
So what's the alternative? How can law schools improve?
Well, the articles strongly advocate for integrating Indigenous laws and legal perspectives right into the core curriculum, not just as an elective or a special topic, but as fundamental legal knowledge.
Why is that so important?
Several reasons. Firstly, their intrinsic value as sophisticated legal systems in their own right. Secondly, their potential to offer more sustainable solutions, particularly in areas where settler law has clearly failed Indigenous communities. And thirdly, just to address the shortcomings and biases of the current system by offering different perspectives.
And there are places doing this.
Yes, the example given is the Indigenous Law Research Unit, ILRU, at the University of Victoria in Canada. Their work in recovering and teaching Indigenous legal traditions led to the world's first degree in Indigenous law, the Juris Indigenorum degree.
Wow, a whole degree. That sounds truly transformative.
It's an incredibly important initiative, yeah. Recognizing and valuing the richness and complexity of these legal traditions, which sort of brings us to think about the well-being of Indigenous law students more broadly.
Because they face unique challenges, don't they? Beyond the usual pressures of being a student.
Definitely. Things like ongoing disparities in health outcomes, economic circumstances, sometimes having had less access to quality secondary education, plus often significant community and family responsibilities. And layered over all of that are the intergenerational impacts of colonization and trauma.
Yet despite all that, and sometimes facing opposition to things like affirmative action programs, the number of Indigenous graduates has grown significantly since 1967.
It really has. It's a testament to incredible resilience and determination.
And what motivates them to study law, given it's been a tool of oppression?
It's often a mix of things. For many, it is about understanding the very legal instruments that were used for dispossession and control. But it's also, crucially, about wanting to become effective advocates for their communities, to drive change from within, and to serve as positive role models for younger generations.
And some universities are doing a good job supporting them.
The ANU College of Law's Targeted Support Program is mentioned as a positive example. It seems to have achieved impressive retention and completion rates for its Indigenous students.
What sort of things do they do?
Things like offering pre-study orientation programs, helping students acclimatize to university life, providing dedicated pastoral care, making sure students know about all the support services available, practical help with things like housing and transport, and really importantly, acknowledging and accommodating family and community responsibilities where possible.
That sounds comprehensive. And they also try to educate non-Indigenous students.
Yeah, that's another key part. They proactively address misconceptions or stereotypes among the broader student body through open discussions, often in compulsory first-year courses, trying to build that mutual understanding and respect early on.
That seems vital for creating a better community within the law school.
Absolutely, because ultimately it's about valuing Indigenous ways of knowing, their epistemologies, their learning styles, bridging that respect gap, as one source calls it, and creating a truly inclusive environment benefits everyone, Indigenous and non-Indigenous students alike.
Finally, the sources touch on this evolving understanding, or maybe misunderstanding, of race and Indigenous rights in Australia today. There's an anecdote about a student comment.
Yes, during a Reconciliation Week talk in 2018, a student apparently commented, quite genuinely it seems, that Australia has an enviable human rights record, but without really acknowledging the historical context of Indigenous dispossession and exclusion.
And that highlights a gap in understanding, doesn't it?
It really does. A disconnect between some contemporary perspectives and the sheer length of Indigenous history and custodianship on this continent, tens of thousands of years, compared to the relatively very short period of colonial history. a history marked by the deliberate exclusion of Indigenous people from the country's founding legal and political structures.
And Australia wasn't exactly quick to jump on board with international human rights norms initially.
No, while those norms shifted towards universalism and racial equality after World War II, Australia was initially quite resistant to fully embracing them, particularly where they might challenge domestic policies towards Indigenous people.
Even though there were earlier moments of recognition, like the Gove land rights case.
That's an interesting one. Milirpum Vina Balco, the Gove case in the early 70s. Justice Blackburn, even though he felt bound by Terra Nullius at the time and couldn't grant land rights, he importantly did recognize Yolju society as having a sophisticated system of law. A government of laws, he called it.
So acknowledging the system, even if the outcome was constrained by the existing legal framework.
Exactly. And then Mologo came along and corrected the Terra Nullius fiction. But even since Mabo, the High Court has sometimes been criticized for maybe not fully acknowledging the ongoing dynamism and evolution of Indigenous cultures and laws, sometimes taking a bit of a frozen-in-time approach.
And we talked about the race power in the Constitution, how it's been interpreted in ways that allowed discriminatory laws.
Regrettably, yes. That power has been used to enact laws specifically targeting Indigenous people, not always for their benefit, however. There's also a clear shift happening in community attitudes now.
You think so?
Well, the sources argue there's increasing public opposition to discriminatory treatment based solely on race. You see that reflected in anti-discrimination laws passed by state and federal parliaments over the last few decades.
So society's views are perhaps moving ahead of some aspects of the constitutional framework.
You could argue that. And it suggests that achieving genuine constitutional recognition and substantive racial equality are really fundamental starting points, necessary steps towards building a society where, as one source puts it, every person is truly presumed to be of equal value.
Equal value. That seems like a good principle to aim for.
Indeed. And it echoes arguments made by some, even way back during the drafting of the Constitution in the 1890s. This pursuit of equal protection and recognition for Indigenous peoples, it's not new, and it remains a vital and ongoing imperative.
So as we kind of wrap up this deep dive, gosh, it's clear that the legal and political landscape around Indigenous sovereignty, self-determination, constitutional recognition, it's just incredibly complex, isn't it? Deeply layered, constantly unfolding.
Absolutely. Our sources really underscore that constant interplay. You've got legal precedent, the undeniable weight of history, the shifting sands of political will, and Australia's place within international law all interacting.
Sometimes pulling in the same direction, sometimes not so much.
Exactly. Shaping both the challenges and maybe the opportunities for meaningful progress. It's never simple.
And it really prompts you, the listener, to consider, given all these historical and legal complexities we've just skimmed the surface of, what do you believe is the most just and also practical path forward? How can Australia best recognize Indigenous sovereignty and rights in a meaningful way?
Yeah, it's a huge question. Maybe even just think about one small step you personally could take to deepen your own understanding of these critical issues. What could that look like for you?
Because this isn't just an academic discussion, is it? We really encourage you to delve further. Maybe look up some of the cases or ideas we mentioned. Continue your own journey of learning and reflection.
Because this ongoing dialogue, this grappling with difficult questions, it's absolutely essential, isn't it, for shaping a more just, a more equitable future for Australia.
A future where the rights, the history, and the continuing sovereignty of its First Peoples are fully acknowledged, respected, and genuinely embraced.